I'd like to call to order the November 21st meeting of the Falmouth Planning Board. Let's see, first thing on today's agenda, there's no minutes. Public comment.
Public.
Is anyone here would like to speak on something that's not on our agenda tonight? Hearing none, we'll continue. Approval not required.
Release.
Release a Highwood Lane bond release. That's what we saw in the file. You want to summarize that for us, Brad?
Highwood Lane is the last bond amount in the Ballymead subdivision that dates back to 1986. Since 1986, the planning board has been approving, various sections of the subdivision, the condominiums, all that goes with it. This is the last release for the Ballymead. It's an amount of $50,000. It's a bond. It's for Highwood Lane. That's that most southern part of the subdivision. And we have the final engineering report, and I can recommend to the board that you can release the bond in full.
And I move that the bond be released in full.
I'll second.
Any discussion? All in favor?
I just had a question.
Question.
How
Quick.
long has the bond been being held? How far back does that go?
I think that bond goes back to like 2001. All the information is there. That's why we brought it.
You want to wait till I read it before you vote?
I was just curious. Some of these bonds go back a long time. I was just curious how long.
Yeah, that went back to I think it was early 2001. It's the last one in a whole list of millions of dollars of bonds the board has had over the years. History here, the first, in 1977 that development started. It was actually a very important Supreme Court case that this board won in 1981. It was called Northlanders Corporation versus the town of Falmouth. And upheld your subdivision rules and regulations as being comprehensive and approvable, that they required a strip of land to be donated for the public way on Sam Turner Road. I remember reading the case when I was in graduate school. That's how far back that development goes. Just a little history. I digress, I'm sorry.
We're going to miss you.
I'm still around for a little bit longer. But yeah, that's the history of Ballymead development, and hopefully this will be the last release, and that will be the end.
All in favor?
Aye.
Aye.
Opposed? None? All set. Approval not required.
FBI agent and a bank examiner.
Applicant Nye Park LLC plans to combine two lots into one located on Country Road. Map numbers 2, 3, 7, 8, and 2. And 2, 3, 7, and 9. Sorry.
Excuse me, that's County Road, right?
County Road, sorry. Thank you.
So it's actually a combination of two lots into one. You see the dotted line that's there.
The line, yep.
So not a subdivision by definition, entitled to the board's endorsement, approval not required.
So I will move that we endorse the combining of these lots without regard to any buildability and so on.
I'll second.
John?
I just want to understand what's happening here.
Yeah.
All of this parcel becomes one lot then? Is that the proposal?
Correct.
Okay, thank you.
So former Lot 8 and former Lot 9 are all Lot A?
Something like that.
Lot 9A. Is that what?
Correct.
Well, it's more than two lots then.
Two lots into one is what?
Well, combine
You help
two
us out
lots, there's
here?
a lot more lots here.
I'll try if I can help you out. I'm Tom Bunker, DSS Design. Much like Brian talking about the history,
This has some
this was the
history.
first land court plan I did as a land surveyor way back when, and now I created lots
Undoing it.
9 now, we're undoing that, putting it back into lot 10. So there are two lots. At one time, they were divided to get the 3 existing buildings on one lot and then a back lot. Went through site plan review with Board of Appeals, and one of the conditions was that it all be combined back into one lot, and that's what we're doing here.
Jim,
Yes.
do you mind saying why?
Excuse me?
Why do you want to do that? Just,
Well, there are
For information.
approved plans to build in the back, and it was just part of, for access and utilities and everything, is just under one ownership, so it's just to be combined into one lot.
thank you.
All good.
So lot 8, 9, and 10 back here are all going to be part of the front lot too.
8 and 9 are the, see, or labeled as former Lot 8 and former Lot 9 are being combined to create Lot 10.
So
Where's the access to these lots then?
Well, County Road is the access to the entire parcel.
Okay, so if somebody owns the entire property, he can put an access road to the back lots and then develop those. Is that concept?
Lot 8, both lots have frontage on County Road. But combined, now they'll have the combined frontage, and it's all going to become one lot. One site plan was approved several years ago.
Well, lot 8 includes the 3 houses then, is that correct?
Yes.
Okay, thank you.
there's a condominium development, as I recall, going in the back.
Or apartments. Actually, the front is condominium. It's
Right.
professional condominium in the front. With that one building, number 111, is the pharmacy. building.
Oh, no, I got this now.
Okay, now,
No,
the secret word.
Thing,
yeah.
and it
It was a
the ballpark.
subdivision, a big plan along, okay,
was challenged as a,
okay.
and there was a challenge on it for a spot zoning challenge? We'll talk about that later on.
Okay, so we're just putting it back together.
That's all you did.
As it was.
Okay,
And remember, board, it's the reverse of a subdivision.
right,
And the only
I'm doing
thing-
it.
And the only thing the board has to worry about is the plan a subdivision? And if it's not, then.
But it's also nice to know what we're looking at.
Oh, yes, oh, yes, but in the end, is it a subdivision?
It didn't make sense before.
We've walked this, yeah, we spent some time on this, okay? All right, I'm all set. Everybody? All in favor? Aye. Opposed? None? You're all set.
Thank you.
Now, I wanted to mention, to watch the microphones. When I was sitting with the television people last week, I noticed every time somebody runs the plans over this mic, it makes a huge rumble.
For 20 years, or 10 years, Rich Latimer.
Yeah.
Rich, if you're watching,
And the
right over the mic.
the people at home, you can't hear anything, and so I just
I know.
had the experience. I thought it was actually Pam that was doing it. She's not here tonight, but I wanted to point it out.
Perfect.
It's probably good for everyone to sit there and listen to it once in a while.
Correct.
Next is a planning board discussion. And the applicant is Kenneth J. Caputo, site plan review to construct 5,114 square feet urgent care medical building located at 40 Davis Straits. And,
So in your folder, you should have a letter
yeah,
asking the board to extend the time frame decision to January 10th. Give you some time to further discuss the architectural elevations. So the board needs to vote that extension tonight. And they'll come back and see you on the 28th. That gives you the 28th, and the 12th, and the 19th to finalize the architecturals.
Paul?
I don't object to the letter for the extension, but the letter does not refer to any specific project. Just Ken Caputo, but doesn't even refer to this particular project.
Other than in the signature.
Well, we have the signature, Caputo, he is the applicant on the application. Your point is well taken.
It'd be nice to have the name of the project on the letter when
Sure.
you request an extension.
Sure, absolutely, you're correct. So why don't we do this, if you can vote the letter tonight, I'll ask Mr. Caputo to reissue it with a reference to the site plan on it. But at least you'll have this vote tonight. Obviously, Mr. Caputo is the representative of Convenient MD. We met the other day. We'll get it right next week.
Pat?
Okay,
Can I
so
just
then,
follow
oh,
up
go
on that for a
ahead.
second, please? Our agenda says urgent care medical building. That's not the name that has been proposed by. It's a different name. And here he doesn't even refer to it, and that's my only concern. I
Sure.
think if he refers to it properly, it would make more sense.
Okay. I see your point, I'm not disagreeing, but we will cure it. My recommendation to the board tonight is that we vote the extension for Mr. Caputo, about the agenda saying convenient MD or urgent care, taken in its entirety, in its harmonious whole. I think a reviewer would recognize it to be the applicant for the site plan review at that location.
And I have another question. Go ahead.
No, you go ahead, because I was just going to make a motion.
Now, he's requesting that this be extended until January 10th, which changes all these deadlines. Is that his deadline now? So we have to meet before that, or what's the deadline after that?
The deadline is on your agenda. So the deadline is actually December 13th. That doesn't give you time to meet certain other deadlines if you wish to involve the county agency. So that's why it's being extended. It also gives the applicant an additional meeting in December for you to review, then discuss, then decide, so you're not rushing.
Well, that's a good point, because we chose, well, basically, you and I chose to have this meeting tonight
Right.
in order to meet a county date if we needed it.
Right.
Are we still, now, those dates are all going to reset, or we still have enough time frame to do that again if we, assuming, what happens if we come to another standoff?
You will have enough time now to meet the county deadlines for 2 meetings in December.
That's what we need to hear.
Okay, so this extension is just to push the deadline, but there will be meetings before that time to discuss this.
You will see this again on the 28th.
That's fine.
Still within your deadline, you notice that? From the original applicant, from the original, whatever it might have been. So no constructive grant will issue. I will make sure that whatever defects lurk are cured. But thanks for the pickup, good pickup.
Thank you. Sorry.
No problem.
Okay, then I am going to move that we accept Mr. Kenneth Caputo's request for an extension of the time period till January 10th for the site plan for the urgent care facility, and that this will give sufficient time, or that any calling of the name of the project will be cured.
Well, just extend the time frame for a decision on the site
Okay.
plan review, and then you should be all set.
Okay.
Okay, second?
All in favor?
Aye.
Opposed? None?
So you'll see this again next week. And there will be no artificial deadlines to meet the county's requirements. Will give you at least 2 full meetings.
Good.
And they are fully aware of the board's thinking on the architectural issues.
Okay, zoning articles for Springtown meeting.
Another reason I wanted to have a quick meeting tonight is that we're going to be running into a real deadline on the annual warrant. It's going to close very early. And I know there are some zoning articles the board briefly discussed and wants to issue in reaction to the town meeting vote last week or so. And the first I have for you is a very simple article that would allow ground-mounted solar photovoltaic arrays as a special permit use. And I'm not asking for the board to vote this tonight, I'm just introducing it tonight. You'll see this again next week, gives you some time. But what this essentially does, it would only be in agricultural A and double A districts only, not agricultural B. Most agricultural B areas are subdivisions today. Northern Central Ave, around, area around Jenkins Pond, those types of areas, probably not suitable. And it simply makes it a special permit use subject to the criteria you see in section 216. The size of the lot, the adequacy of utilities, all the standard special
Neighborhood
permit.
character,
Neighborhood
views and
character,
vistas.
Views and vistas. It doesn't have any delimiters like we see with the contractor's yard. It has to be at least 5 acres. It can't be in a water resource zone. You have to have enhanced setbacks or whatever. It is simply made a very simple special permit use, and left to the discretion of the Board of Appeals as to whether or not, because it's going to be so varied, whether or not they could require additional buffering or setbacks, is the site suitable or whatnot. I didn't add any kind of special permit criteria. I think 216 probably suffices. So I just asked the board to think about that. Just a special permit use, is it a fairly passive use? Gravel mining, we have a lot of delimiters. Contractors' yards, we have a lot of delimiters. Boat storage. You see, if you look at that bylaw, you'll see they all have additional criteria up above and beyond 216. So take a look at that. Think about it. That's what I propose for your consideration at this point. It's an extremely simple change, but it does have some implications for these agricultural zones. Having these types of arrays of any size. It could be a 1 acre, 2 acre, it could be half an acre. Whatever it is out there in an agricultural zone. So think about that. If you have any initial comments or discussion, that's fine too. When we go back to the drawing board, this is a terrible idea, we know. But the clock is ticking for the annual town meeting. As an aside, there will more than likely be a special town meeting in April too. That gives you till about end of January, maybe early February to think about these matters.
We will have a public hearing just on this.
Sometime probably in March or sometime in February. But if you have to vote something to the warrant before the warrant closes.
Right.
The hearing is after the close of the warrant.
So the hearing is how we formulate our recommendation for
Correct.
town meeting.
Correct.
Now, this would have, well, I can remember, this has been brought up before, and I actually was against it because I was afraid that these things would be showing up in front of houses and all the other, the developments, but the solution is to put it in A and not B, is that correct?
Right now, the A requires a 45,000 square foot lot, double A is an 80,000 square foot lot. There's more areas suitable for that, I suppose.
And the fact that it's
In
not a
these
by
areas.
right use, it's a special permit, gives the
Right.
control for views, vistas, neighborhood character, and all the other things that the zoning board would take
Right.
care of.
Correct.
So if we had done this last town meeting would have come on,
There are some other issues, lot coverage. There's some vagaries out there, what we'd have to consider and talk about. What is the lot coverage requirement? Is it impervious? All that things that go with it, but we can cross that bridge when we get to it.
yeah, I was going to bring up discussion, but we'll wait till we have the, okay.
At least get it as an allowed use. So if you had a 65-acre parcel out there, even if at the worst, 40% of that would be some 27 acres, right? 30 acres. You might be able to use for total lot coverage.
Are they considered structure?
Sure,
They are?
sure. Sheds water, right? Moves it to a different
Yeah.
direction, sure. It's on a block.
So then would there also be a site plan review?
We haven't done that because it says 1,000 square feet
Yeah, that's what my question.
we always assume to be habitable space.
Okay, so it's structure but not habitable space. so-
Right. Or does it
But
require?
does our bylaw say that, or just say 1,000 feet of structure or 5 parking spaces?
Gross floor area.
Gross floor area,
Gross
okay,
floor.
that's it, okay. That's the difference.
Or does it need more than 5 parking
5
spaces?
parking spaces.
And no parking is required, So it's never triggered a plan review through the board, through this board.
Okay.
And it's been a by right use, so not a special permit from the Board of Appeals. This will now bring it to a special permit use. Does it need a site plan? Probably not. But does the Board of Appeals have the ability to condition it, appropriately condition it with, say, landscaping or buffers or whatever? Sure.
Neighbors will be notified, the butters list is sent, all the
All the-
protections are all in place.
Correct.
Pat?
I really would like to get the feedback of the zoning board on this.
Okay.
I would feel far more comfortable because they're going to be the ones that are the special permit issuing agency. And I'd really like to get their feedback as to
Sure.
whether they want to see a minimal lot size with it
Okay.
or anything else added to it other than just 216.
That's a perfectly, good call. So I'll support it along, say, do you have any initial thoughts and comments? Do you want additional safeguards? And,
Yeah.
Or are you comfortable? If they're not, then, see you in April.
Yeah, because I'm comfortable with doing this, but I'm uncomfortable with the broad breadth of it
No problem.
until we get some feedback.
We'll send it along for their comments. 'Cause
Thank you.
You won't have to vote this technically till, later on December, before the warrant closes.
Mhm.
My understanding is going to close like the first week of January, maybe,
Okay,
right,
that gives us time.
right.
Paul?
Are you suggesting that the town planner and the administrator for zoning talk about this? Or are you suggesting they put it as an agenda item for them to talk about it in general? What kind of mechanism are you thinking about?
I'm not concerned so much about the mechanism as the fact that I'd like to get the ZBA members to look at it and to weigh in, because they're going to be the responsible parties. And whether they give Sari feedback and she gives it to Brian, or whether they draft something that Sari then sends on to us. I'm not so concerned with that as the fact that we get some feedback from them.
Well, I'll ask for it to be forwarded to the board members if they could discuss it at one of their meetings, and briefly, that'd be fine. We have some time.
Thank you.
Yep. Unless you want to be the special, no.
No, no, no.
No, thank you.
Oh, come on. What could
Any, other-
possibly go wrong?
Any other articles that you have?
Yes, the other article in here is to simply add accessory apartments to general residence districts. It's been brought up a couple of times by petitioners. It's either going to be a petitioner's article or it's going to be your article, because there are some cases in general residence districts that are pending or want to be able to apply. Like we said, we thought it was okay, but this makes it perfectly clear that it's a special permit. I mean, it's a by right use, just as we have in the residential and agricultural zones. It would be a by right use in the general residence districts. General residence districts comprise like 1% of the town's planned area. It's very small. That area around the Belvedere Plains, there's a bit around T-Ticket Highway. There's not a lot of it around, but, Palmer Avenue.
Locust Street?
Locust Street, right, but might as well include it because they are highly developed and densely developed areas.
And I think this was an oversight. Paul?
I noticed this particular draft has not been posted on the agenda. Should we bring it up another time and post it? Because there's a lot of interest in town on accessory apartments.
Yeah, well, what we have here is, this is what was voted at the town meeting. As you remember, we took out some verbiage about being on the same lot or accessory there too. Mr. Herbst made an amendment on town meeting floor. So what you see here is simply what was voted on town meeting floor, and it was approved by the Attorney General's office. Just for your background information tonight. If it's the board's will to essentially amend the bylaw, then again, we would have a hearing.
So we don't have a draft of the changes, this is just for discussion purposes. This is,
Yeah, you'll see article to see the town will vote to amend Article 6, general residence districts, by adding the following. It's that simple.
okay.
Boom. And then you have.
Oh, it's that one line.
It's that one line. That's
Not
all
the
you
whole
need.
page.
That's all you need.
Okay.
Because this is the bylaw that was already approved.
So Paul, everything else is the bylaw, the only writing is this one sentence.
And it's what was approved at town meeting whatever it was back in April.
I see that. My only point is I don't see it on the agenda.
Yes, it is. Articles for Springtown meeting.
It's not spelled out.
That's,
It's not indicated well.
Right.
My only point is there's a lot of interest in the public
absolutely, we'll have this.
on this issue. And I don't want it to appear that we're doing something without having a public hearing on it, that's all. I don't think we are.
No, we're not.
We're not.
We're talking that we're going to have a hearing in the future.
Do you
We're
want-
planning.
Right, do you want to have a hearing?
Yes.
Right. Do you want to introduce an article for the town meeting, and then have a hearing, and then make a recommendation? That's what this is about tonight. This is
Do we
not
need to vote on that, or we just say?
No, just take a
The
look.
feeling, it looks like
There's
everyone
thoughts
wants to.
on it, and then that's the new section number. We added a new section. Sometimes I just ask the board members to double check me, take a look. We'll get it out there. It's public knowledge. Now you're thinking about it, and then vote them probably either next week or the 12th of December. We won't be meeting, the board won't be meeting on December 5th.
Okay.
But essentially, the other issues that have come up in the past, some folks have offered the suggestion that it might be beneficial to simply have if it's a special permit from the Board of Appeals, then make it simply that for the accessory apartments, and not have them subject to a plan review. That suggestion was offered. I don't think it's at this point appropriate, because the site plan is supposed to expedite the special permit, and you're still doing the design review stuff. So, but that comment has come forward. We might want to consider that when you get out to a hearing. I'll just put that thought in your mind at this point. But right now, it's just, here's the article, accessory apartments in GR districts, is that a good idea or not? Go out and visit those districts. It's good to take a drive around, they familiarize, this is a general residence district, is this a good idea? And off we'll go.
Okay.
So, a little homework. And then we come to the main event.
Yeah. General correspondence, tutorial.
Everyone's going
Right
to
over
get,
that.
everyone's going to get.
I think I've had it a couple times already, but I think it's important for everybody to have it.
I thank you for doing this.
I've never given this before. This is for this board, it's on spot zoning.
Well, I guess you've,
Because I just put this together last week, and I finished it today. That's why you didn't get it in your agenda
Exact one.
packages.
right. We have had this discussion more than once.
Oh, yes, we've had this discussion. But here's a little,
It actually came up really hard when we were doing light industrial C. Everyone was saying it was spot zoning, and we had to prove to them, well, it's got to go someplace. We got to start off as long as it's part of a plan.
we're going to get there. Yeah, it's an often misunderstood term. What is a spot zone? That sounds horrible. What are we going to do about that? So I thought it was a good idea. I'll go back to the mic, don't worry. Got a little clicker here. So I just thought it would be a good idea to just take some time for your benefit and the public's benefit, and if any town meeting members, want to take a look at this too, that'd be fine, because it's an often misunderstood term. So last week I started putting together this little fairly low-level, not a high-tech tutorial. This is not for the professional planner types or anything like that. So it's really kind of bare bones. If you want more information or want to delve into the weeds, we can get you all that information. But this is really just for the board's edification on a very general plane. So when you amend the official zoning map, oftentimes you'll hear people say, well, this looks like a spot zone. Well, what's a spot zone? So how do we spot a spot zone? I thought that was very clever of me to put that in there, but obviously. So we're going to have these four main talking points tonight. And I did print this out for you. If you have some questions, write them down. we can always revisit this if you want, if you don't quite understand, or if you want some more information. But here are the 4 talking points I thought were very important for the board to understand, and that is, why do we care? What's the big deal? Okay, it's a spot zone. Why is everybody in a kerfuffle about that? I think the second talking point we'll have tonight is, well, what happens when town meeting votes a zoning article, when it goes off to be reviewed, either by the Attorney General's office, or if it goes to court, what's their standard of reviews? What are the rules out there that the legal beagles have to follow when they take a look at what you have done? And let's just say, for the sake of argument, it's past the legal beagles and it's going to go to, some sort of judicial review. What are the ingredients that they're going to look at? What's a reviewing court going to look at? What if this is truly an impermissible spot zone? So what are the tests out there that they're going to apply? And then we'll go through a few examples, because we have some here, we have some out there. I have the most recent land court case from Swampscott. My daughter works for that firm. That's an advertisement, but it's the latest case from the land court. It's a trial level, it's not an appellate level case, but it's sort of instructive for what the board members may want to see as truly egregious. The land court said, no, spot zone. Try again. So why do we care? Well, we care because, and we're going to be going back and forth a little bit on the constitutional and statutory grounds. You'll see that later on. Spot zoning is forbidden on both constitutional and statutory grounds. Pretty big stuff. And this is some language from a very important court case. You can read it, or I can read along for the people at home. That is, if you're going to use the zoning power to only, that's parenthetical, affect a private benefit, it constitutes a denial of equal protection. We've seen that in zoning cases all the time. That's why we have variances. It's all about equal protection. I can't zone you over here this way and then do a little bit over here, tweak over here just for you, because it's a deprivation of the equal protection clause of both the U.S. and Mass constitutions. It's also a statutory requirement. That's why we care. If you look at the Zoning Act in the Commonwealth of Massachusetts, that's Chapter 40A, Section 4. You've probably heard this term before. It's called uniformity. And you can read it for yourself. If you divide a town into districts, you have to be uniform within the district for each class or kind of structures or uses permitted. Simple as that. It's right there in the general statute. You're not supposed to do it. We sort of do that a little bit more for special permit. We might have some criteria in there, but you're supposed to be uniform. The setback for you is this. The setback for you is this too. You can't say, well, the setback for you is this, but over here we're going to have that. So that breaks the uniformity clause. Equal protection issue on that can't be done. So a spot zone is a big deal because it deprives you of a constitutional guarantee. And the Great and General Court of the Commonwealth has indicated that they don't like it either. Okay, so we have to pay attention. So when the term comes up and the challenge is there, it's because you're depriving someone of a equal protection under the law. So what are the rules when it comes to adopting a zone change on a map amendment? What's the standard of review? We talked about a second talking point. And this is really sort of important. The standard of review, it's the challenger has the burden. And the burden is characterized as, quote, heavy. We'll get into that case a little bit. The benefit of the doubt is with you. Any reviewing court or any attorney general's office, the burden is on the challenger. You get to sit back and relax for the moment, and that burden is fairly heavy. And that's because, I'll get to you, Paul. as a legislative decision, courts and the Attorney General have to grant you great deference, okay, because it's a legislative decision. That was somewhat back in the 40s, was decided that way, even though it's a local town meeting. They view it as a legislative decision. There's that separation of power. You know, that the judicial branch is loath to overturn a legislative decision, as is the executive branch, the Attorney General's office. So the benefit of the doubt is with you. The burden is on the challenger, and great deference to your decision is afforded to you by the courts and the Attorney General's office. So you are sort of in the driver's seat. So when those challenges go out, you have the benefit of the doubt, first and foremost. And I'll get into that a little bit more. So this is the language from the case. Every presumption is made in favor of the bylaw. Its enforcement will not be refused. Beyond a reasonable doubt that it conflicts with the Constitution or the enabling statute. That goes back to my first slide, that you have to really be sort of egregious on those equal protection in uniformity matters. And this is the language right from the Supreme Court case, and the citation is at the bottom. And where the reasonableness is fairly debatable, then the judgment of the local body, legislative body, the town meeting, must be sustained. And this case is 70 years old. And the standard is fairly debatable. Is it fairly debatable? Is there a scintilla of argument there? And it was somewhat recently upheld again by the Supreme Court. In this case, you know, the burden is heavy, it's on the challenger, and they must prove facts that compel a conclusion that the statute is not even fairly debatable. It's just totally egregious, and you sort of have a case there in your hands there from Swampscott that crossed that line, and that's what you have to do. The challenger has to show that the town or the city act essentially egregiously, and it's not even fairly debatable. So again, you are somewhat in the driver's seat. Here's a factoid.
The you in that sentence is town meeting.
In this instance, town meeting, or city council, or town council, or who votes the zone change. So here are some statistics and factoids for you of all the challenges that have come through, and that we can, literature search. 75% of spot zoning challenges have been upheld. In other words, the town, you're fine, the city, you're fine, you did just no big deal. There's some scintilla of argument. It's fairly debatable. What you did is consistent with the Constitution and the enabling statute. So the burden is very heavy. I bet 750 out there, and we'll get into why it's 75%. It's actually easier to have a reverse spot zone challenge upheld. And I'll let you know what a reverse spot zone is, because there's really two types. There's a spot zone, and there's a reverse spot zone, where and they have been reversed about 50-50. And I'll show you why that is the case. But most of the time, spot zones, you're just going to be just fine. So what are the tests? What are the ingredients that make you suspect? And there are essentially three. It occurs when you take a small area. It could be a lot or an area, whatever it might be, and you single that area out for treatment less onerous than that imposed upon nearby, and this is really important, indistinguishable properties. So I might have some lots on Nathan Ellis Highway near the intersection of Route 28A on the north side. And let's say they're, in 20,000 square foot lots, zone general residence, near across from the Beach House restaurant or whatever it is now. I think we all know what we're talking about.
Bocatino.
And it's, practically indistinguishable. And they're zoned residential, and we single out one of those lots for treatment less onerous by rezoning it business. But there's nothing to distinguish that property. It's indistinguishable, and we're treating it less onerous than that of nearby properties. Number two, the zone change is designed, and that's important, solely for the economic benefit of the owner of the property receiving special treatment. There are no tangible public benefits whatsoever. And we'll get into some exceptions later on down the road here, but it's just solely for their benefit. I have a house in a subdivision of lots of houses, and I want to turn it into a business. It's just for my benefit. I can't really find any other tangible public interest associated with it. And more importantly, you saw the first two, we're treating an area less onerous, indistinguishable. The economic benefit inures to the property owner, pretty much, and it's not in accordance with a well-considered plan for public welfare. So there's three kind of tests out there. And we're going to get into a situation here where, especially number 3, is somewhat of a trump card out there when it comes to a spot zoning challenge, because there are exceptions to every general rule. So we had the less onerous, indistinguishable, solely for economic benefit, and not in accordance with a well-established or well-considered plan for the public welfare. Exception number 1, of course, to the general rule. If you can show economic benefits that inure to the town, it might be an increased tax base. You might greatly need retail space or contractor space, something that you've identified as a true public need in the community. If you can point that out, you will probably be able to survive a challenge on exception number 1 here. Exception number 2. You meet all the criteria, less onerous, indistinguishable, solely not according to a plan, but, the effect of the amendment on the municipality as a whole, especially where the growth of the municipality has been addressed by a plan. Very often, sometimes, there might be those times where people might say, well, gee whiz, you're coming to the town meeting with the local comprehensive plan, and it's sort of a, feel-good exercise. It might be true, but not when it comes to the land use element. If you have a well-considered growth plan for your municipality, you will more than likely be upheld on any spot zoning challenge on God's green earth, because you're going to fall into exception number 2. And some of the examples would be, that we discussed before, contractor yard issue. It's the 4th largest, but in terms of wages and salaries of the economic sector of the town. We have a plan for it, and we're going to go out and remap as an exercise. You're probably going to be upheld. In fact, I have an example for you.
In our land use local comprehensive plan, policy number 1 is that we will continue to review zoning changes that are beneficial for the town. Does that pretty much?
That's a little bit that's kind of squishy, a little amorphous.
No, but that's what it says.
But if we have something in there for an action,
Right, if it had an action item,
we want
then it would be dead on.
Then, especially where the growth of the town has been addressed by a plan.
Right.
And we're going to get into that a little bit more.
All right.
Okay.
Right.
That's exception number 2. So exception number 1, you can show without the benefit of a plan, there is some public benefit. It's not solely for the profit motive of the property owner. Number 2 is, well, this amendment affects the municipality on the whole, and it's especially where the growth has been addressed by a plan. In other words, do you have an LCP or similar document that's been voted? And we will see that later on in the Attorney General's letter I'll show you. So your local comprehensive planning, when it comes to certain housing, economic development, land use, they're going to take a look at that. It's going to weigh very heavily. Because all you have to be is what? Fairly debatable. some scintilla of reasonableness, and you're going to be upheld. And exception number 3 is if you rezone, obviously you meet the public benefit if you're going to rezone a piece of property, or say the housing authority, so you can put in affordable housing. That inures a public benefit. You're going to come in under number 1 and probably number 2. But these are typically left undisturbed by the reviewers if you're doing it for a public entity, even a town. There's something out there that inures to the public.
So the landfill kind of comes out of that.
Yeah.
So I mentioned briefly a reverse spot zone and how they are typically singled out, and you lose more often on reverse spot zones than a spot zone challenge. Because intrinsically, when you rezone someone's property, you're usually adding value. Most folks don't say, gee, rezone me so I lose value. So there's going to be that sort of, introduction of economic expectations with any zone change. But on a reverse spot zone, you essentially single out a piece of land for treatment more onerous than imposed upon indistinguishable properties nearby. I have a piece of property, it's zoned business, and I'm in a industrial area, and I decide that, or we decide as a town, well, we think you'd be better off zoned for, single-family homes. That's a reverse spot zone. And those challenges are typically, it's 50-50. So that's not the best of odds. But those are the types of challenges for spot zoning that are typically reversed. Not the types of zone changes that go from, say, residential to business, or whatever it might be, light industrial C. Those are typically upheld if you reach those exceptions. But these spot zoning challenges, a reverse spot zone, are really more fairly scrutinized. And more than often, 50-50, you're going to get reversed. Because they are equally violative of uniformity and the principles of equal protection. I'm not treating you fairly at all, or nor am I being uniform in the district for each class of use and structure. So what's the take-home lesson for the planning board? Remember exception number 2. If the amendment is consistent with the LCP, and it's part of a planning process, you are more than likely going to be upheld every single time. Because the example I'll give you might be the letter I'll show you is based on the rezoning up on Tom Landers Road.
Because we were challenged on that.
You were challenged on that at the Attorney General's office. The other example I was talking about was the Mr. Manazian on Route 151. He appeared before town meeting 3 or 4 times. And in fact, the recommendation of the board was that it was an impermissible spot zone, solely for the economic benefit of the property owner, not consistent with the plan, can't show any tangible benefit to the public whatsoever. It was a 20,000 square foot lot, a row of 20,000 square foot lots, indistinguishable from nearby properties, spot zone. But let's just say for the sake of argument, it was part of, well, we need more, whatever it might be there, up there, it's a fairly debatable arguments, you might have been sustained. But that was no planning process, indistinguishable, the whole 9 yards.
Those are 2 really good examples that we dealt with ourselves.
Right.
That makes it really clear to me. I know the other guys weren't on there, but we did both those.
Right. So the board members who were there at the time, we can see that distinguishing characteristics between
That makes it clear.
the light industrial C on Tam Landers Road, and we'll show you these, the other newer board members. There's 2 acres, that was all it was, pretty small area.
Looked like a spot zone, except it was part of our plan.
It quacked like a duck, it walked like a duck, but, that was in 2012, was Article 9 of the April town meeting. It was challenged at the Attorney General's office. They asked for all the documentation. It took them, whatever it was, they took the 90 days plus 30 days extension that we gave them. And I just want to show you the excerpts from the letter.
Is that the one that's near the corner of, of 28, Route 28?
in Tom Landers Road on the south
Tom
side.
Land- yeah,
On the
okay.
east side of 28, south side of Tom Landers Road.
And we were challenged heavily that that was spot zoning.
Right.
They came at us pretty hard.
Okay, but the other one, it's harder for me to follow, because that's the one right across from what is now Bucatino's Restaurant,
Right.
next to the parking lot for the restaurant.
There's a parking lot and a house,
Right.
and
right,
then the electrician's house, I think, is right there.
Right.
And then
Higgins
there's
there, and then,
Right, there's a subdivision behind it.
mhm.
And it's all zoned residence B, I think it is, single residence B.
Even the restaurant and the pizza parlor?
Across the street is business.
Well, but there's
Right.
the parking lot for
And then
the
there's
restaurant, and then there's the pizza
There's a
parlor.
pizza place. The parking lot is zoned residential.
Ah.
Right. And the lots that are near it are all zoned residential.
Oh, okay, I didn't know that.
Next to it and behind it. Right. So it was in the midst of it, an area that's somewhat indistinguishable.
Mhm.
Although further down the road a little bit was a business zone. We weren't extending that business zone, or we call that nibbling at the edges. This would have been a little spot of business zoning, essentially in the middle of a residential area.
And it wouldn't have been adjacent to any other business zone. It was
Correct.
It was definitely a spot.
The other example I'll give you is the Nautilus Dome site. It's one parcel, one owner. It was zoned residential. It had the restaurant and the hotel. It was rezoned business redevelopment. It was part of your planning process was to take some areas that would need revitalization or redevelopment and zone it appropriately. That was one 7-acre parcel, one owner. The size of the spot is not holding. You get the larger the spot, the better, but it's not dispositive. It's not determinative. That's another example of where your planning process wasn't challenged, but a planning process, business redevelopment, revitalization of this area that needs to be revitalized, more than likely would have been upheld. So this was challenged. This was a 2-acre parcel of property. It was Ag AA, and town meeting zoned it Light Industrial C. So just take a look at the letter that came from the Assistant Attorney General. It's paragraph 1, and she very adroitly gets into the standards of her review and the authority of the town to do zoning. And this is quoting out of the first paragraph of her letter. Does it look familiar?
Mhm.
Every presumption is made in your favor. The Attorney General must cite an inconsistency between the bylaw adopted in the town, by the town, and the constitutional laws of the Commonwealth. That's, the Section 4 of 40A and the Carnes case. And if the reasonableness of the zoning bylaw is even fairly debatable, it must be sustained. So that's what she was looking at. Okay, this is what you've done. This is what I must look at as the Attorney General or the Assistant Attorney General. Yes, you can vote to treat certain parcels within the town differently from other parcels so long as you do so for legitimate purposes. And they can't conclude based on the information we gave them that you did anything else. The planning board made the recommendation. It was appropriate and consistent with the stated goal of what?
The local comprehensive plan.
Ding! And based on the materials submitted, you are good doobies. And that, in a nutshell, really is all about spot zoning. If I do it solely for the economic, I take a small area, I set it aside for treatment less onerous, the other, indistinguishable. I have a lot of land, I'm going to zone it business so I can put a burger diddle on it, and it's in the middle of a, whatever it might be, subdivision. And it's only for the economic benefit of the property owner. I can't find any public benefit whatsoever in the retail sales, whatever it might be. And it wasn't in accordance with any kind of planning document of this board. And Nathan Ellis Highway is a classic example of a spot zone. And the light industrial C on Tom Landers Road, it has the characteristics of a spot zone. It might have been a economic benefit to the property owner, sure. Was it indistinguishable? As I recall, it was vacant. It might be of a distinguishing characteristic. But the most important thing in the Attorney General's letter was that the burden is heavy. The burden is on the challenger. If the board can even come up with a scintilla of something fairly debatable, I will uphold you. Is it consistent with the local comprehensive plan? Bingo.
There's an action item, yeah.
Every single time, you will be upheld. So those are the tests. So let's go to the most latest example. You looked at a light industrial C zone up off of Gifford Street extension. And the board looked at it in its harmonious whole and said, is this an area suitable for light industrial C? We need more light industrial C. We need more ground-mounted solar voltaic arrays. You may remember we went through a very lengthy process to find gravel pits.
Right.
We talked to Mr. LaRusso. We talked to the people, the property owners in the area, that this might be a zoning designation you may want to consider. You actually reached out to the property owners in this area for that type of a land use. You will more than likely were going to be upheld because it's part of your planning process.
But
Right.
we didn't reach out to this particular parcel. It was a little bit further away, but you think it might have been covered anyway.
Well, you looked, you surveyed the area of those types of land uses.
Right.
Did you reach out to this particular owner?
Land use is exactly the same as the
It's
way we're
it's
doing it.
identical.
Exactly.
It's identical. This is the type of land use you want to have to be revitalized and reused. We reached out to several in the area, but not this one particular one. But was it also consistent with your local plan? Yes, it was. More than likely,
What about that?
you're going to be upheld. The burden is on the challenger.
Brian,
The
who
presumption is with you.
Is it an automatic challenge? Everything we do goes to the Attorney General for their approval, right?
If it's really egregious, they might pick it up. Now, the Swampscott case, it's usually someone's going to come.
Someone has to write a letter to.
Usually
pick it up.
speaking, because, again, there's 300, Cambridge and Boston have their own zoning bylaw, statutes, doesn't affect them, but 48 affects all the other cities and towns, so they get hundreds and hundreds of zoning bylaws. So it's going to have to really stand out. Usually it's someone calls, someone makes someone does something. I haven't heard too many cases that they actually pick up on their own. Or it can be challenged later on, just as the A&R plan you just saw tonight. That was an extension of the B3 district. That was business 3 zoning at the pharmacy. And you may recall that they actually extended that zone on that piece of property. This is going way back out. Actually, maybe Pat was on the board.
I was.
I was on the board, too.
Were you on the board? Okay.
Well, I was on the board when we were,
Doing the planning.
yeah, the site plan,
But that was
not on
actually,
the zoning.
that was actually an extension of the zone
Right.
back in the
I
day.
was there for the second.
Sort of nibbling at the edges, but challenges a spot zone in court later on. I don't know what happened to that case. It may have been just been dropped, but more than likely would have been upheld because, tax base or what. You can show some public benefit through this rezoning, employment, whatever it might be, probably going to be upheld. But that's the take-home lesson, is that don't be too concerned about a challenge. Oh, this is spot zoning. A spot zone has all those ingredients, and even then, if it's part of your planning process, more than likely going to be upheld.
So it's more than likely, if it's part of our planning process, in an article that we're bringing up, and it's because it's part of our goals and objectives, it's going to be covered under this, and this is probably more likely with an applicant bringing it up just for their own benefit.
More than likely, it's a here's the latest, or the last appeals court level case we're familiar with was in the town of Monson. Monson is way out there in the Pioneer Valley somewhere, I forget exactly where. Nice little town. And they, in their wisdom, decided that it was a good idea to take this apple orchard, a couple hundred acres worth of apple orchard, wherever it was, and take 10 or 20 acres and zone it industrial. And for whatever reasons, compelled them. It was indistinct, it was setting aside an area for treatment less onerous than nearby indistinguishable properties. It was apple orchard, solely for the benefit of the property owner. No tangible benefits, even though it was zoned industrial, I don't think it was for jobs, or it might have been for condos or whatever it might have been. And that was the last appeals court case that was held as a spot zone and reversed. And that was in 1985. That's the last time it's reached the appeals court. So it's fairly rare. I think Swampscott, I can't remember the last time there was a spot zone challenge that was upheld practically in my career. They're fairly rare.
Well, that's where Charlie Baker lives.
Swampscott?
Mhm.
Oh, there you go. But they're fairly rare. You have to really be egregious. The town of Swampscott took a piece of property that they owned, whatever it was zoned, and said, well, we want to maximize the benefit of this property, so we're going to zone it, whatever it was they zoned it, purely for the town's economic benefit. And the land court said, you can't, no, if you read the case. That's the last spot zoning challenge that was upheld, that we're familiar with, and that was 3 years ago.
When we were looking at Nathan Ellis Highway, we had the guy that wanted to rezone his parcel, but didn't we look at rezoning that whole corner, or a section of that corner?
Yeah, we were looking at that as a sort of a starting point.
Yeah.
And then we were going to talk to the other property owners in the area, worked our way down
Yeah.
Thomas Landers Road. We
Yeah.
talked to Mr. Cavosa. He did eventually agree to light industrial C up on 151.
Yeah.
I think we talked to Mr. Briggs, not Briggs, on Burkillen Road, other large contracting
Yeah.
yards. So the board made an effort to go out to find areas that are suitable for this rezoning, and you added this use because you thought these old gravel pits have already been stripped of their trees. You don't want to take a green space, strip down all the trees, and put in ground-mounted arrays. So that you've already stripped it down to the water
You
table.
won't get the SRECs doing that, they won't give them to you.
Right, right. So this is a classic reuse of a piece of property that the planning board looked at as part of their planning process that was suitable for this zoning designation. More than likely going to be upheld. Right. You have to, part of your plan. If it's just kind of willy-nilly, I bought a piece of property, I paid too much for it, I want it rezoned to get back my investment. There's no tangible benefit to the town, there's no planning behind it. That's a spot zone. Right.
It would seem then that spot zoning is a more political use as a way to talk something down than it is otherwise.
Again, the town meeting members will see it, oh, well, it's one parcel, it's owned by one person, there'd be an economic benefit. Oh, that is their definition. And it's very natural to think that way. Because typically speaking, a rezoning inures a economic benefit. But there are the exceptions. You know, the Attorney General said, yes, you can treat certain parcels in that town differently, so long as you do so for a legitimate purpose. And we can't conclude that you lack a legitimate planning purpose. We did our studies. We reached out to property owners as part of the planning process, voted by town meeting. You're probably going to be okay. So if you apply all the exceptions, then not a spot zone. If you don't apply all the spots, and you say, well, a spot zone is when I have one parcel and it's being upzoned, spot zone, then I can see how you reach that conclusion.
Procedural question then about town meetings. If a zoning issue is coming before a town meeting and it's being opposed by a town meeting member who rises to say, oh no, this is spot zoning, would it be within the purview of the moderator or some other official there to say, just a moment, let's consider that and have what amounts to an answer on, is it spot zoning, given to the town meeting members? Or is it just passed over?
Charlotte, I'll address that because I was at the meeting, I was the presenter on this article. Well, we just read it. I wasn't really the presenter. But I actually asked the applicant Are you gonna get up and say anything? And they chose not to defend their position, so I just let it go. I knew about,
I can understand that, but I'm just wondering procedurally, if it would be appropriate, say, for Mr. Vieira to have said, that's a reasonable challenge, we need to know what are the rules around spot zoning, in which case there would be an appeal to the knowledgeable person there, some official who would say, this is spot zoning and that isn't. So they get information at that point in order to consider it. The defendant may not have had the right language, the proposer may not have had the right language to make that case.
That did come up when, when those couple of acres were rezoned on the corner there. And we have an awful lot of historical background on that, because many years ago, we were looking at those particular corners to be rezoned as light industrial or industrial. They were the logical places because they were the exits right off the highway, so you had good access there. So many years we were looking at that. We also had a historical discussion many times over about Tom Landers Road and potentially rezoning the gravel pits and acquiring some of them to do it as light industrial C. So when that challenge came up, it was relatively easy to tell town meeting that, no, this is not coming out of the blue, it is not spot zoning, because this is part of the long-range plan that the planning board has been discussing and is intent on pursuing over the years when and if those properties become available. I might have been the one doing it, I don't even remember, but.
I'm not in a position to get up into a 15-minute treatise
Right.
on spot zoning, that the town meeting members are in their totally right to, thank you, Mr. Curry, but I'm not here to debate you, right? So this is for your edification, and those who might be interested in it. There might be people who will look at this and say, well, I'm still consider it to be spot zoning, that's their right. But at least you as town meeting members and planning board members, here's the background, and if asked the question, if you can demonstrate that there's some public benefit, and that's something, again, that's the town meeting member has to judge it. How much tax base, how much employment, is this really?
town meeting could accept that position, the spot zoning, and if they vote it down at town meeting, it's done.
It's done.
It's done, it's not our argument anymore.
Right.
But if town meeting accepts our position, and it isn't, and then it goes to challenge, and it falls into this criteria, then we're gonna get upheld.
Right, so it's more of a political argument than
Right.
it is a technical argument at town
If
meeting.
they win the two-thirds vote, or
Right.
whatever, it's over.
Right.
That's their, discussion's over.
Right, but, you know,
Because they are the legislative body.
and
Town meeting.
this and planning board, if you have all this information, you'll never bring a spot zone to town meeting. Usually these are challenged when it's a petitioner's article. And in this case, it was a petitioner's article. Both were petitioners.
Right,
One
they
didn't
were.
get to two-thirds, I guess it was.
Yeah.
But had they passed and gone to the Attorney General's office, it's my opinion that they would not have found a spot zoning. You would have been upheld. And that is how we do that, that level. Now, if you want to read more about it, I did reference the cases, and there's lots of stuff out there for you to read, but I think at this level, a little bit of knowledge is dangerous, the whole,
Right.
but,
For this board, it's really gonna be
Right.
the town planner's job to keep us on the right track.
But
You shouldn't let us go down this road.
but just, absolutely, but just like anything else, you should have some background information, what's, an approval not required plan like we discussed tonight. The only question in front of the board is, does the plan depict a subdivision? It's really straightforward and ministerial. It's nice to know, well, why are you doing this, but it's not germane. What kind of building is this? That's interesting, but it's not germane. Technically, legally, the only thing in front of you is one question: is it a subdivision? Subject to further review. Good to have this background knowledge.
Right.
So when you do amendments, you have this tool. When it gets to into the weeds, yeah, your professional planner should be able to get you through the weeds. I hope.
I think it's very helpful on this presentation, but I had a question.
Yeah.
3 or 4 times you mentioned the term heavy. The burden is heavy. Is that a legal term? Does it refer to the size or value of a project? What's the
Yeah.
implication of
I'm
heavy?
heavier than everybody else.
Number 7 had it.
Yeah,
He ain't heavy, he's my bylaw.
He's not heavy, he's my brother.
the burden, that's from an actual case. That's from an actual case. The burden is characterized as heavy. That quote is from an actual case. I don't have my notes in front
Is that a
of me.
legal term, heavy?
It's the language used by the Supreme Court. The burden is heavy. Right. The burden has been characterized as heavy.
It seems to be rather
It's like-
undefined.
It's like capricious, whimsical.
Well, I think it goes with the word burden.
Right. The
Yeah.
burden has been.
Okay, if you think of it with,
Right.
associated with burden,
I'm just trying to figure out if it's a legal term or whether it's just a sign of,
No, I think, I have the case, it's in my notes, it's in the computer, but, it's a Supreme Court case, and they said, the burden on the challenger is a heavy one. You just can't walk in and say, I think this is a spot zone because, whatever it might be. You have to demonstrate to sustain the burden, you must prove facts that compel a conclusion that it's not even fairly debatable. Oh, what did you do? Oh, we rezoned it so we could sell it get more money. Down a swamp? No. It's not even fairly debatable. There's no public purpose there. It's not the town's job to make money. And the court, struck it down. But yeah, you must prove facts, compel a conclusion. And it can't be even fairly debatable. And that's 45 years old now. Right. The burden is on the challenger. The burden is heavy. Off you go. And that's,
so this is our take-home notes.
it's your take-home notes, and, the take-home lesson is to remember exception number 2. If you plan it out, and even if it's, trying to think of another example, it might be business redevelopment on an old hotel out there somewhere, in Woods Hole or elsewhere. But if you have a planning process, you've developed this to revitalize and to redevelop, properties that need some capital, probably going to be uphill. Right.
But looking forward, now we're thinking about the Davis Straits, possibly redevelopment zone, possibly an overlay district,
Yeah.
a new zone for multifamily housing, to make some change there. But it's large enough, it's certainly serving a public purpose, but the
Right.
plan at the moment
Right.
is the plan that was given to us by the Cape Cod Commission.
Yeah.
What standing would that plan have?
It was done for you. It's your plan. You can vote to adopt it, but it's a part of a planning process. It doesn't have to be voted at town meeting as part of the comp plan. It's more of an action plan. It's better than no plan. You can show the Attorney General's office, well, we planned this area out with the Cape Cod Commission. This is our thought process. We're going to do this and this. There wouldn't be a spot zoning challenge. It's the same way we did it on East Main Street. We took all that business to zoning and made it business redevelopment. It has to be a fairly small area, The spot's not, dispositive, but if you rezone 45 acres something, along a strip of a highway, or how many acres are there, it's not a spot zone by definition. It's not a small area indistinguishable from other
Or a
areas.
taking, or anything like that?
No, there's no taking. Remember, whenever people talk about, diminution of property values in the Commonwealth, the test case was a case out of Dedham, Massachusetts, years ago in floodplain zoning. Turnpike Realty Trust versus Town of Dedham. 90% diminution because they had some floodplain conservancy district overlay, 90% value diminution, not a taking. It has to be devoid of all residual value, and you're left with the burden of paying taxes. But in this instance, you're usually enhancing value. And our job here is to do just the opposite. We want to be able to revitalize and enhance value, bring in jobs, bring in economic development, bring in tax revenue. It's all legitimate in this area. Public purpose, the whole bit, all will go. But when you ever see, when you hear the spot zone challenge again, think in your mind, all those criteria. Does it meet the criteria? And then, more importantly, and this is where sometimes town meeting members make this mistake, naturally they don't have this information, does it meet the exceptions? If it meets one of the exceptions, not a spot zone.
Okay.
All righty. See, planning can be fun. Yeah, John, thank you, John.
I have one comment, if I may. Jim?
Yes.
I have one comment. There's a pretty heavy reliance on the LCP in this whole presentation.
Yes.
If a community doesn't have an LCP, does that put them more at risk for this spot zoning challenges?
That's my opinion.
Because
Then-
this, all through this LCP.
You bet. You saw the Attorney General's letter. If you can show it's part of your planning process, and it's exception number 2. The exception number 2 is court-driven. You're going to be upheld. You meet the exception. And the classic example is, well, let's just say for the sake of argument, there was no planning process, and someone came in and said, well, I have this new zoning district. I want to rezone my property. It's 2 acres on Tom Landers Road for my economic benefit. I want to produce, I want to put an anthrax bomb factory in or something. There's really nothing that, I could consider more important. More than likely, spot zone. But because you went through this planning process, it's a 2-acre parcel. Of course, you're enhancing someone's value. That's okay. That's okay to do. The courts say it, the Attorney General says it's okay. It's kind of built in. Then it would be a reverse spot zone, not a spot zone. But you're doing it to inure benefits to the public. The fourth largest, wage and salaries is contract trades. And we're doing this because they need a place to go. And what more logical places along the big highways and roads? It was a no-brainer. It took them 10 seconds to figure that. Not a spot zone.
And for about 2 years, that wall was covered with
Yes.
plans of that area. Every selectmen's meeting that was, it all had all that vision of what we were trying to do up there on that wall. Brian had put it all up, so anytime we wanted to talk about it, we could just refer it. So it was
Right.
definitely part of a 2 or 3 year planning process.
But to get to Charles' point too, I mentioned the planning process in the LCP because the town meeting voted, a lot of legitimacy, but the Davis Straits or similar document, the local or similar document. The similar document would be your reset study.
Reset study, yeah.
Falls within that. Right,
It-
okay.
With, or similar document. That's the exception that, has been generated out there. So there you go. And it's fairly debatable. Are you doing something? Or is it truly whimsical, for the solely for the economic benefit of the property owner?
Okay, I think we've covered this one. You all set?
Yes, thank you.
You want to talk
very
about
much.
some more? That's what we do for a living.
Any more questions, Charlotte?
No, and I appreciate the time given this, thank you.
Yeah, no, we had a little time. This is good. You're going to be busy again for the next few weeks. So this is a good way to get this in here.
Okay, general correspondence, there's something from, a covenant from,
Oh, yes, if you could, there's a covenant in there that, for the Sandland Family Trust on, not Crescent, what's the name, Cedar Street, not Cedar Street, Cypress Street. That's that subdivision that was just approved and went through court. Now they would ask the board, Corey and I have reviewed the covenant. It comports with your standards, and I can recommend you sign it.
okay, so we'll want to pass it down, start down that end.
Do we have to vote on that, or are you recommending it, we just sign it?
I wouldn't have you sign something I wouldn't sign. It's just, it's a road covenant. You can't sell, convey, or build on the lots until such time as you put the road in. And usually what they do is they covenant with you first, they bring the road up to like a binder course, and then they bond the rest.
We all have to sign it?
I need 4 signatures. And because it's a covenant that runs with the land, usually I have like the planning board sign, the majority of the board signs. You can vote, like you just voted a release of bond, you can also vote releases of covenant, and then I simply sign on your behalf, because I'm just signing as an authorized agent of your vote.
They haven't signed this yet.
And,
They haven't signed it yet.
oh, they will. They want to record the plan, they have to sign it. Usually I do have you folks sign it first, but they're, usually just come into the office. But apparently there's a rush. Not a rush, but it's Thanksgiving. They probably want to do some certain things by the end of the calendar year for tax purposes. I just need 4.
I'm amazed there's any land here.
Might as well get some extra signatures while we're at it.
Yeah.
Future agenda items, you can take off spot zoning.
You don't want to do that?
Just tuck it back.
Feel
We
compelled,
will
John?
be talking of Davis Straits next week.
We're going to take spot zoning off the future agenda item.
There we
Well,
go.
I had that for town meetings. Actually, it was a 4-slide presentation, really quick, so it's just adding to it. Takes a couple
Oh.
days.
Just put it back in there, hand it.
Oh.
So town meeting did see
Hand
that,
it to Brian.
or some version.
They were going to see it as part of the presentation on one of the articles, but we didn't have to use it. I'll take that back.
Okay, future agenda items. So we definitely want to have,
Well, as Brian just said, we'll be doing Davis Straits,
right,
right?
which will include multifamily discussion as a component, right?
Yeah.
Yes, what I'm hoping that we'll be able to do, what Pam and I are hoping we'll be able to do, is take a look at the overview of it so that we can get the purpose section that we have been, admonished to have first. What are our purposes that we all agree on? And perhaps what are the broad parameters that we want to be sure are included in it? And what would be the technique, maybe, if we get that far? But mostly the purpose and the broad parameters.
Next week.
Next week?
Next week, because
Okay.
I want to talk to the board about that too,
All right.
about how that is going to move forward in the future. Right.
Any other items, Paul?
Yeah, Brian was kind enough to introduce me to the new housing coordinator the town has hired. At some point in time, maybe not this next week, we probably should talk a little bit about the kinds of things we're interested in and how we can provide some input to her if appropriate. I know we have a little subcommittee on that, but we may want to talk a little bit about what our involvement would be and how we might contribute to that whole process.
Okay, I mean, part of our housing plan has 3 things we're working on. One of them is the multi-family housing zone. You thinking other things other than that? The accessory apartment bylaw, which we've done?
Not
And the
necessarily.
conversion bylaw are 3 things that we have agreed to move forward on as part of our work. You have opened up for other things, or you?
Well, now that we have that coordinator, that's been a long time coming, and she has a big job to pull all these pieces together, we probably should talk to her about what our interests are from a planning standpoint, and what we might want to do to support that.
Okay. Well, would we have her come to our meeting? We can't summon her to us.
Well, it's too premature to do
No,
that.
I would say
Just
sometime
started.
in the future, when coordinator comes up on the curve a little bit here. Probably something, maybe after town meeting. Have a conversation about, the local plan, any action plans that are out there. I know they're going to be working on this housing production plan. The housing production plan needs the approval of this board. That's a DHCD rule. The selectmen must vote it and you must vote it.
We don't do it. Somebody else is doing it. We just approve it. Is that correct?
So the last time Marlene and I did it, that was
Okay.
2009, and I did it before in 2003. And this board was actively involved.
So housing production plan should be on our agenda in the future then.
I think an update of it is fine. I think, but the board needs to be engaged in that process when it comes out for a final say, because you must vote it. DHCD will not accept it. The state won't accept a plan that's not voted by this board. They do that for a very specific reason.
Could you describe how the board was involved in the past?
We would bring you drafts, you know, we can involve you in the process of alternatives, solutions and whatnot. We didn't get you into the weeds about all the projections and demands and stuff like that.
Was there a hearing on it?
I can't remember, I don't think so. This is
So
a-
there were just board discussions,
Board
no hearing?
discussions, right. And then it went for a vote, and then it goes to the selectmen for a vote, and then it goes to the state for approval. It's good for 5 years. I think as a planning document, it's good to have. Some folks think we should have it as a safe harbor, you know, for 40B purposes. I think that's a bad idea. I think it's more valuable as a planning document, because you have to develop, I think, 75 units in a calendar year to have a safe harbor for the following year. You have already voted, and town meeting has already voted, that it's housing for everyone, irregardless of artificial state, what do we call it? Requirements. So we, or you as a board in this town has voted that document. So unless you want to go back to when we want to strive to meet 10%, the goal is housing for everybody. Maybe that's something that we can discuss with the coordinators, that's the public policy that this board has brought forward. Should be aware of that.
Okay, so we'll have that on there.
At some point in time, I'd like to see an updated review of the bylaws.
Yes, that's coming in December.
Yeah.
Coming when?
I mentioned that last week, it's coming in December.
December.
And that,
Thank you.
one of the reasons I'm putting it off is because of town meeting, and you're gonna have a bunch of decisions again this next week, a lot of regulatory reviews. And so I want the board to be able to focus on what they're, like Bob Squared are gonna bring you. But yes, it's on the short list.
Thank you.
Yep. Probably December 5th.
Future agenda items, any needs or wants down there?
That's right.
No?
I won't be here the 5th.
Okay, the next item is, our next meeting is November 28th.
28th, so you'll have 3 or 4 decisions, and you'll see convenient MD. And if you're comfortable in the zoning articles that we saw tonight.
And that
And Davis Streets, so it'll be a busy day.
Completes our agenda.
I make a motion. We adjourn.
First and second, all in favor?
Aye.
Thank you.
All set. Thank you, everybody.